Instead of focusing on winning arguments, we're teaching the basic fundamentals of sales and marketing and how we can use them to win in the world of politics, teaching you how to meet people where they're at on the issues they care about. Welcome to The Brian Nichols Show. Well, hey there, folks. Brian Nichols here, another fun-filled episode of The Brian Nichols Show. I am, as always, your humble host, joining you from our lovely Cardio Miracle Studios here in sunny Eastern Indiana. The Brian Nichols Show is powered by the best heart health supplement in the world. So if you want to learn how to lower your resting heart rate, lower your blood pressure while improving your pump at the gym, stick around. We'll talk about that more later in today's episode. But first, we're digging into all things free speech. What's at stake if age verification, that is, comes before the Supreme Court? Age verification for what? Yes, accessing those naughty magazines and websites. But in today's conversation, more on the naughty websites. So just discuss all that and more. Joining me here on the show today is David McGarry. David, welcome to the show. How you doing?
I'm doing very well. Thank you very much for having me.
Absolutely. Looking forward to digging into today's conversation. I know we're talking all things age verification. This is a topic as a new parent myself that's become more in my purview. And I guess, for a lot of folks out there, it's becoming more and more real because as the younger generations grow up and they have access to these little supercomputers in their pocket, all of a sudden, things that were traditionally inaccessible to your average minor all of a sudden became not only accessible, but you could pretty much access anything in the world, good, bad, and all that in between. But before we dig into the topic of conversation, David, do us a favor, introduce yourself here to the Brian Nichols Show audience and why you're focused on these different free speech issues that we're going to be talking about here today.
Well, I am the research director at the Taxpayers Protection Alliance here in not so sunny DC. It's very swampy at the moment, both in terms of the terrain and also in terms of the humidity. We are an organization that focuses on the economic and other effects of regulation on the average taxpayer, the average American citizen. And for the purposes of today, I am thinking quite a lot about age verification in tech and the implications for free speech going forward into this digital age we have entered. There's sort of a misconception, I think, that the digital world, quote unquote, operates by different rules than the quote unquote physical world. There are a lot of people in both parties who think that the ordinary knowledge problems or constitutional constraints shouldn't necessarily apply to the regulation of the internet in cases in which it seems like things are a little bit crazy online. So I have spent quite a lot of my time researching and writing about exactly why this is a bad idea and why we should, in fact, apply the Constitution with just as much rigor, and why the First Amendment should apply with just as much force to online speech and online expressive activity as it should anywhere else.
So talk to us about the argument here, because as a parent, right, and this is where I think I've maybe taken a step more towards I don't want to say pro-censorship argument, but pro-restriction for minor argument, because I look at the world, and elephant in the room, David, the world's a messy place. It's a scary place. And when you have a kid, it becomes more apparent of how there's a lot of nefarious forces out there who would absolutely love to get into your kid's purview. It's indicative on me to play the role of parent to help keep my kids safe. And I've seen a lot of the arguments on both sides of the aisle, the pro-access arguments, the pro-restriction arguments. And I really think that each has its own merits in the arguments themselves. But when it comes down to the actual application and we're putting these things into practice, I'm a little torn because I see the importance of protecting our kids. I've seen, and I think we all have seen, it's a big push to more or less sexualized children, which for a lot of parents is a ginormous red flag, right? But then to your article's point, this is also now starting to bridge on the line of free expression, free speech. So just for the audience today, and frankly for yours truly here, just help outline your argument. Like what is the best position to say, hey, you know what, you might not like this stuff, you might not like it being on the internet, but here's why putting age verification and all these different loopholes to access this information is actually a bad thing. What's your argument there?
Well, by way of background, let me give a little bit of explanation about what this case, which was recently decided at the Supreme Court, was about, what principles are implicated, and what questions are raised about the future of the internet. So, in 2023, the Texas legislature passed a law that essentially required all websites which host at least 1/3 of the content hosted is obscene material, which is essentially targeted at porn sites. They were required to verify the ages of anyone visiting those websites. And the decision at the Supreme Court that recently came down said essentially that obscene material is not protected for minors. And therefore, the state has an interest in blocking minors from accessing that material. And therefore, age verification was entirely permissible, and that any restrictions on the ability of adults from the age verification process to access this obscene material were sort of ancillary and couldn't overcome the state interest in stopping minors from viewing porn. More or less straightforward, right? Now, let's talk about what this case, in my view, is really about, because I don't particularly think it isn't necessarily about pornography specifically. And it goes far beyond minors. So the reason why age verification has been looked askance at in the context of online speech and online content is that it places a huge burden on access to that content. And we're not talking about minors here, because again, I should clarify from the outset that nobody wants minors accessing porn. Full stop. However, the process of age verification is very burdensome. It essentially involves at the moment giving, say, a scan of an ID, or maybe scanning your face before you access the age-gated online service. And the question that is raised by the Supreme Court's decision is whether the principle that states can impose age verification will be applied to the broader world of online speech. So essentially what this means is that, can the government mandate, say, a social media company to collect your data, which then makes it vulnerable for hacking or might compromise your anonymity should you wish to keep your anonymity intact, before you are allowed to go on and engage in basic First Amendment protected speech online, say on Twitter or on Facebook or on other platforms? And the court tied its language pretty closely to obscene content. But it's unclear whether that principle, the principles established in the opinion, I should say, will be extended to other social media platforms. And the way that this could manifest is that in the future, another case challenging an age verification law for social media generally, for online speech generally, could make the case that, sure, we don't want kids having unmitigated access to some of these social media platforms. Now, I should note that a lot of the data tying social media to mental health problems for kids is very shaky at best. But the question will again sort of be, if we can claim that some sort of digital service, some sort of online speech could be harmful to some minors, does that mean that we can burden the First Amendment right of adults to access that speech or to speak themselves? And I think this is very concerning, because there's a very big difference between a society in which people can think and speak freely and express themselves online and find new information and engage in debate, and a society in which the access to online speech is predicated on you giving up information about yourself, very sensitive information, to a database of either a third-party verifier or a big tech company, or, according to some proposals, to the government itself, in a way that could compromise your privacy and compromise your anonymity. The question is, should the access to online speech be predicated on a show your papers regime? before you are allowed to go on and exercise your basic First Amendment rights. And as I said, it's not entirely clear where the Supreme Court will fall on this. I tend to think that there will likely be a majority in other cases to cabin this recent decision specifically to obscenity, and to say that age verification is permissible, or I should say mandated age verification by the government is permissible in the context of obscenity, specifically because there's a long-standing traditional belief that the state has a duty to prevent minors from accessing this sort of thing. And that simply can't be, that standard simply can't be applied to online speech generally, but whether or not it will play out that way remains to be seen.
You're trying to stay sharp, whether it's for work, learning, or just not forgetting where you left your keys. Been there, but lately, the mental fog hits hard. And brain fog isn't just stress. It's often tied to poor blood flow and low nitric oxide levels, because your brain needs oxygen just as much as your other muscles do. Because without it, you're slower to process, less focused, and more fatigued. And that's one of the many reasons why I trust Cardio Miracle. Not only does it boost nitric oxide for heart and circulation, it supports cognitive clarity, focus, and even mood regulation thanks to its unique blend of L-arginine, CoQ10, vitamin D3, and antioxidant-rich superfoods. So if you're tired of feeling mentally cloudy, give your brain what it's craving. Click the link in the show notes, scan that little QR code over my shoulder, or head to cardiomiracle.com/TBNS, which will give you 15% off your order. Just look for the little note on the website saying you're shopping with Brian Nichols. One more time, that's cardiomiracle.com/TBNS. And now, let's get back to the show. So I guess the main question I would have to start, David, is what would be the fundamental difference in the IRL in a marketplace, right, where I'm physically going into Family Video, right, RIP Family Video, another relic of yesteryear. I used to work at Family Video, by the way. I used to have people actually come in and buy video or rent videos. Good times. We didn't have one of those back room sections though, but for the movie places that did, you wanted to go, look at, name your fun little video you want to watch that night, right? I think back to the beginning of Dodgeball, where he's getting the phone call of the movies he has late that he has to get back, and you can go watch that to hear the names. I don't want to get banned on YouTube in the first 10 minutes of our show. But like, what I guess is fundamentally the difference between engaging in that marketplace where it's in person versus an online marketplace? Because here's my question in the context therein is, if little Timmy, he walks into Family Video and he's like, I want to go to the back room, please. And, me at the counter, I'm like, Timmy, you're 12. Sorry, no, you can't go back there. No, I'm not 12, I'm 18. And then they show me their license, right? And it's, the bench warmers, I am 12. Only it's I am 18 in this case. So like that for me, I guess I'm a little, it's not I'm stuck, but I'm definitely hearing that there is an argument to be made that, well, David, there's nothing fundamentally different from little Timmy walking into the video store and trying to access this content and being told no by the gatekeeper versus going on to name the erotic website or the obscene website, and that would be accessible on the internet. But like now they're just asking for more or less what I would have asked for if little Timmy had walked into my store. Is the crux of the argument that the online, tool is going to be getting our information, and then that it's a security issue, it's an anonymity issue? Is that the argument? Because like if that's the case, I'm a little stuck there. Because if I'm in my community and I see a little Timmy walk in, chances are I know little Timmy. I know little Timmy's family. He's not anonymous. I know who Timmy is, and I'm probably going to say something to his dad, like, "Hey, little Timmy was in the store today trying to go to the back room again." Like, you should probably address that at home. Help me square that. I guess I don't want to say contradiction, but it does feel that we're trying to apply rules to online world that we would not apply here in the real world. Does that make sense?
Well, I think you've hit on one of the fundamental points that the Supreme Court failed to grasp in this decision. There is a inherent distinction between offline age checks and online age checks. If you do walk into the store, right, and you look at somebody's face, no harm, no foul, you send little Timmy out. I don't know why little Timmy's always getting up to the hijinks that he's getting up to, but apparently in every hypothetical he appears. Or say the person behind the counter checks your ID, looks at the age, says, okay, you're under 18, or in the context of, say, you're trying to buy booze, you're under 21. That's it. You get booted, and the interaction is over. But what we're talking about with online age verification is far more invasive to privacy and creates far more risks down the road for privacy. The way that the Texas statute will likely work is that you will have to, as I said before, either take a photo of your ID, scan your ID, this government issued documentation, and upload that to a database, or you might have to use some kind of tool that would gather biometric data. So, say a facial scan, something like that. First of all, that when you're memorializing data in that fashion, it is far more invasive than a quick ID check at a brick and mortar location. And that data, after the initial invasiveness of the process, becomes liable to hacking. It becomes liable to all sorts of data breaches and whatnot. And we have very good evidence. I mean, everybody is hacked constantly. And actually, Justice Alito, who sided with the majority, sort of unintentionally admitted this during the oral arguments for this case. Third-party verifiers that specialize in this kind of thing routinely get hacked. Big tech companies get hacked or fall subject to data breaches. Even the federal government gets, in state governments, falls victim to this sort of thing all the time. So again, there's a world in which the Supreme Court cabins its reasoning in this case specifically to obscene content and says pornography, obscene content, that is something different. That is something that is an area in which we are going to allow extra burdens to be placed on adults accessing this sort of content. But once you extend that out into the broader realm of speech, I do think you have significant civil liberties concerns. Again, like the idea that to go outside in the quote unquote physical world and say something, you would be required to submit to this same sort of invasive process. That just wouldn't be tolerated. That wouldn't be tolerated either legally under the First Amendment, or simply wouldn't be tolerated by the American people. They would object to that. They would see that as an incursion upon their ability to speak freely. The First Amendment, the First Amendment is something that isn't, or I should say, the right to free speech isn't something that is gatekept by a government sign-off. You're just allowed to go out and say and say what you want, and to make your arguments and to hear what other people have to say. This becomes increasingly important again in the social media context, where we have seen laws passed in various states that require users not only to verify their age, but then underage users to provide parental consent before they're allowed to make accounts. So if you'll follow me here, this gets a little bit technical, but the way this process would work essentially is not only is the age and the documentation of the user being checked by a verification service or by a big tech platform, but then you need to then you would need to verify the age, the identity, and the relationship of the parent, and to show that the child and the parent are actually related, and that the parent actually has the legal authority to provide this parental consent to allow children to get on the internet. And in that case, you would have to submit even more data than just an ID or a facial scan, which is problematic enough in and of itself.
So let me run this past you, because as you're kind of talking through things, it sounds like the main argument here is now not just the burden put on the individual to access the information, but to your point, the potential ramifications of having that data now collected. Now it is a threat for hacks, and I think back to, I think it was in the 2010s, there was that well-known case where Ashley Madison, which is a website for serial, I don't know, I don't want to call them swingers, because that's not the right word, but if you wanted to go and cheat on your spouse, you'd go to this website, and they released 90 or there was 100% of the records when it got hacked, and like 97% of the accounts were all dudes. So like that kind of stuff happens, right? We see that happen. But I guess if the main argument that I'm hearing today is that it's the burden being put on the person trying to access this information that is considered obscene, the first question I would have is, number one, is there an inherent right to access these obscene materials? And if so, well, maybe not if so, maybe it's a separate question. And then the other question would be, to the online piece, because of all the things you mentioned, the burden on the actual consumer, I guess, in this case, right? If it is an underage kid, then needing the parental consent, and then to verify that the parent stuff. I mean, these are all things, back to the original point, that would happen in real life. Like, I see little Timmy walk in, I see mom and dad with him. Like, I need to confirm if little Timmy's trying to buy alcohol, right? Like, I need to confirm with mom and dad, that kind of stuff. Not that you could sell alcohol to a kid, but you get my point. But those are the things that we would do in real life regardless. So is it more that we're now just adding the same process, but now just because of the nature of accessing that material, now we're putting more information at risk? Is that it?
Essentially, but let me try to tease out something about the First Amendment law around obscenity, which I think will clarify some of these issues. Obscene content has a slightly unclear relationship to the First Amendment. There's a lot of Supreme Court law around it, but it's not as clear cut as the relationship of non-obscene speech to the First Amendment, because again, there's less protections when it comes to minors, but also adults still have some sort of right to access it. It is considered in some sense speech. So there's a world, I think, in which the Supreme Court decision is completely cabined, as I said, to obscene speech. And the new rule would essentially be, if it's obscene, there's a lower standard of protection for adults' access to it. If it's if adults, if the burdens that adults face in accessing obscene content is incidental to protecting minors, that's a rule. And I think there would be some operational problems with that if we can get into that later if you're interested. But that's a narrow reading of the ruling that I think would have a limited effect on larger free speech issues. However, if this opinion is read as applicable to age verification generally, with respect to all speech online, this is where we start to get into the problem, or I should say the biggest problems. And so let's put aside things like Ashley Madison, because while they're quite hilarious on their own, let's talk about something more about, like, going on Twitter, right? There's lots of reasons why people want to be on Twitter or on Facebook or I guess not Facebook or Instagram, because the services themselves don't allow don't allow anonymous speech. But there's lots of reasons why people want to go online and access information while doing so anonymously, right? Or while doing so without giving up this sort of personal information. There's reasons that you could quibble with or subjectively say are invalid, but there's also very good reasons. There's people who, because of their professional status, or because of chaos in their personal lives, don't want others to know exactly who they are. And then I think secondarily, everyone wants to keep their personal information safe from data breaches and hacks and things like that. So any kind of argument about I would say any kind of argument about obscene speech specifically, or any argument that centers too narrowly on obscene speech, misses this larger principle about does the First Amendment apply online at all in this context, in the context of age verification, right?
Running a small business means adapting on the fly, hiring, scaling down, shifting teams based on seasonal projects. But most phone systems, they lock you into a set number of users and then make it a pain to adjust. And on the contrary, that's where Level 365 shines. add or remove users anytime. Month-to-month plans, scale up when you need it, scale down when you don't. It's flexibility that actually matches how your business works. No headaches, no overpaying for empty seats. Just phones that move with you, and that is what makes Level 365 different.
We certainly don't want to live in a world offline where you essentially have to compromise your privacy or anonymity just to make yourself heard or to access information. And now, just due to the nature of technology and society, more and more conversations are happening and more information is being disseminated online because those are the tools that are available to people to spread information, to spread knowledge, to have arguments, to have debates, to decide everything from sort of cultural debates to important public policy debates, or just to more frivolous interpersonal things, to socializing. So much more of life occurs online now, and so many more aspects of life take place online, which once took place in the quote unquote physical world. So we have to decide whether or not we're going to have a separate standard for the online world, and whether we are comfortable as a society erecting far higher barriers to entry for the exercise of basic constitutional rights and civil liberties online than we would be comfortable with in the physical world.
So I guess it really comes down to the word obscenity, right? And that's the real crux of the conversation today across the board, because and just, going to our friends over at Perplexity AI, I just did a quick, tell me about obscenity in the First Amendment. And here's what it spit out, right? Is obscenity protected by the First Amendment? No. Obscenity is not protected by the First Amendment. The U.S. Supreme Court has consistently ruled that while the First Amendment broadly protects freedom of speech and expression, there are specific categories of speech that are not protected, and obscenity is one of them. Key points: obscenity defined. Obscenity refers to a very narrow category of sexually explicit material that meets certain legal criteria, is distinct from other forms of sexually explicit expression, such as pornography, which may be protected unless it meets the legal definition of obscenity. Supreme Court rulings, the landmark case Roth versus the United States in 1957, established that obscenity is, quote, not within the area of protected speech and press. The court found that the First Amendment was not intended to protect every utterance, and that obscenity, being utterly without redeeming social importance, falls out of its protection, which then leads to the Miller test. The current legal standard for determining what constitutes obscenity comes from Miller v. California in 1973. And under the Miller test material, there are three different criteria they look at. One, the average person applying contemporary community standards finds that the work appeals to prurient interests. Number two, the work depicts or describes sexual conduct in a patently offensive way. Or third, the work taken as a whole lacks serious literary, artistic, political, or scientific value. Therefore, government regulation, because of obscenity being unprotected, federal and state governments can regulate or prohibit obscene material without violating the First Amendment right. The legal definition of obscenity is much narrower than the everyday use of the word. Not all offensive or sexually explicit material is considered legally obscene. Only material that meets the criteria for the Miller test falls outside of the First Amendment. Therefore, in conclusion, says Perplexity, obscenity is not protected by the First Amendment, and the government has the authority to regulate or ban material deemed legally obscene under standards established by the Supreme Court. So I read all that because, David, at the first blush, I hear the argument from a free speech standpoint. But I look to see how the free speech argument in this case, in defense of what we would, I think, across the board determined to be obscene, right? Like, think of some of these gay pride parades where you have literally fully nude men exposing themselves to literal children. And I think it was in Oregon where we saw this one video come out where a dad was trying to get one of the police officers to say, hey, this guy is trying to flash himself and expose himself to my child. And the police officer says, I can't do anything about it, until he actually engages in trying to do something considered quote unquote obscene, right? So we see, the very real life kind of limitations, but also the applications of the social stigma around obscene behavior, or the borderline obscene behavior. And I guess my main point, I would say, is, from just even reading that quick Perplexity little nugget there, but like it does seem to me that because this is not considered traditionally free speech, right? Truly obscene behavior is not considered true free speech. That if there ever was an argument for government to say, hey, we're going to put these thresholds in place per our constitutional model, it sounds like this would be the one area that would make sense, despite the concerns from a privacy standpoint. And I empathize with those. My day job's in the tech space, so I trust me, I get it. But like when you kind of lay it out like that, your average person, I feel, is going to hear the argument of saying government is restricting literal children from accessing obscene material. Okay, I get it. Where is Perplexity wrong? Where am I wrong?
Well, it's not entirely right to say that obscenity is unprotected by the First Amendment completely. And this actually specifically came to a head in the Supreme Court's decision. Again, the one that I've sort of been criticizing or expressing skepticism.
And this is the Free Speech Coalition versus Paxson, right?
Precisely. The standard of review that was used by the Fifth Circuit, the lower court in this case, was incorrect. The Supreme Court said, because there is an incidental effect of age verification acknowledged by the court on adults' rights to access protected speech. But again, the phrase used in I believe this is in the syllabus of the court's decision, is an incidental effect on protected speech. And what that essentially means is that adults do have some protection to access this speech without government interference. But what this law, according to the court, is really doing is targeting minors' access to obscene speech, which is not protected, and therefore the burdens placed on adults' access to this speech are quote unquote incidental. Now there's certain problems with that because the principle that lays out, if extended, could mean that any restriction on adult speech could be justified by predicating it on the protection of children. And again, this is why I sort of keep steering away from the specific porn context, right? Because there's lots of people out there based on largely dubious evidence saying that social media is toxic for kids, and there of course unrestricted access to technology for kids is probably a bad thing. If they're spending 8 hours a day on social media, that is not good for kids' mental health. It's not good for adults' mental health. These things can certainly be taken to excess. But a future regulation that imposes these sorts of burdens on the core First Amendment protections, or the core First Amendment protected speech of adults, could be justified theoretically by extending the logic of this court to say that we are trying to keep kids off of social media or restrict children's access to social media, and therefore any burdens placed on adult speech are, again, quote unquote, incidental. So again, Perplexity has the case law a bit wrong there, unfortunately. I should say the case law before the Paxton decision wrong. And again, the question is, did Paxton simply lower the protections that apply specifically to one kind of speech, or did it establish a new standard for all speech in which the speech of adults can be burdened and regulated at will, so long as there's a justification of child protection?
Well, but David, isn't the overarching point though that it's not speech? That was kind of the point that Perplexity was making, that right. Obscenity.
That's what's incorrect.
Okay, help bridge that gap for me, because I'm having trouble, because there's one thing to say, there's that one very, I think, I can't remember the lady's name, but like she was an artist and she put herself in the middle of like a town square, and she basically said, you can do whatever you want to me for 24 hours, right? And like men would like take her clothes off and do that kind of stuff. And it was a whole thing back in the 70s. And like that was considered art because she was doing something in an artistic expression. is there even an argument to say that like legitimate sexual acts on pornography are speech? And in what separates that from like literal prostitution? If we're just saying, okay, there's a camera now and now it's speech.
Sure. No, that's a fair challenge. And again, this gets back to some of the murkiness of Supreme Court doctrine around obscenity. Under current case law, says the Supreme Court, there is expressive content to obscene material that places it under the protection of the First Amendment. Now, if you're doing that around kids, obviously the effect of say exposing yourself in public, even in protest, there's something more than simply doing an expressive act and then allowing adults to consume some content about that expressive act by their own choice, and doing that in a public setting, which would be the case with some sort of indecent exposure law, or in this case, we're just cases generally about restricting minors' access to obscenity, which then shifts over to the prohibition would be about preventing minors from accessing or from experiencing the obscene material, not preventing adults from accessing that expressive obscene material.
Is that
it's sort of about it's about what is the logic that arrives at the regulation of the content?
Well, and it just seems like, back to your point, though, it comes down to stopping kids from accessing what we can I'd say traditionally considered to be destructive or obscene behavior.
Right, but
like, if it quacks like a duck and it walks like a duck and it looks like a duck, it's probably a duck.
Right, but the question with any with any speech regulation, or really a lot of regulations that implicate constitutional rights and civil liberties, is what are the ancillary effects on protected rights that spring from regulations that are trying to solve a narrow, discrete problem. Does that make sense?
Let's address that really quick, because like I have to go, when I moved to Indiana, I had to go to the Indiana BMV. What do we call it here? I don't know. The DMV, BMV. I had to get a brand new license, right? Which was in essence a restriction of my ability to travel freely, even though I had that right when I lived in Philadelphia, and likewise in New York. I'd gone through the process of getting my license through those different state entities. I was given permission by the government to drive on the roads that I paid for. But moving out here, because they have different state regulations and laws, in order to drive on the road, even though I'm an adult, I still had to go through a burden in order to access that, because, by the way, we don't want 12-year-olds driving on the road because they're not fully developed yet. So if a 12-year-old tried to drive on the road, they would get pulled over. They're obviously going to be in trouble because they don't have a license. So like, what's the fundamental difference there? And we're talking about automobiles versus, in this case, accessing, call it what you will, but I would say obscene material on the internet. I just like this is where I think your average person hears it and they're just like, I get the argument, but I'm not buying into the argument.
That's fair. I mean, the first caveat I would just put on what I'm about to say is that the jurisprudence surrounding First Amendment, or I should say restrictions on free speech, is different from things that the jurisprudence surrounding things that regulate non-expressive activity. So the body of law that has been built up in the courts over the last 250 years or so differs between expressive activity and other activity. However, with respect to your specific example, which I think is a fair challenge, I'd just like to address it from a more, big picture principle perspective. The idea of a driver's license is that driving is an inherently dangerous activity. If somebody engages in driving in a irresponsible way, they are threatening the lives and property of the people around them.
I could make the same argument about obscene pornography online. It's just, maybe it's a longer term before you see the actual outcomes. Is that fair?
Well, I think the corollary to, or the corollary to a driver's license would be regulating the people making the pornography. So again, I don't think it's quite a one-to-one comparison when you are comparing the two. But also I would say the the question is also how narrowly tailored is the solution to the problem. How many ancillary effects are there if you impose this sort of regulation, and what are the dangers of those effects? Because again, if you're sort of trying to solve a very, again, sort of just to give a better understanding of the concept involved, if you're trying to solve a very narrow problem and then you use a very blunt instrument, a very sort of a very poorly tailored regulation to address it that has tons of other negative effects and contain tons of restrictions on other people's liberties, the courts might come in and say, listen, I get you're trying to solve a very real problem, and that is either okay, or that's a good thing, or that's within the purview of the legislator in this context, but you're doing it in a way that places such burdens on other rights of Americans that it cannot pass constitutional scrutiny.
But I mean, even taking let's look at the potential ramifications of the driver's license example. And I understand, to your point, the jurisprudence behind building up these arguments is a little different. However, just like let's keep the logical train going here. When I go to the BMV, DMV, wherever it may be, I'm giving oodles of information. I'm giving my social security numbers, in some cases my birth certificates. Like you're giving them like crazy identifying information for them to capture it and now make sure you are who you say you are, right? They're not immune from being hacked. They're not immune from having cybersecurity breaches. So I mean, it feels like I could almost make that same argument. Like, well, this is against the rights of this is putting more undue burden on me and potential risk on me as the person trying to drive the car. We should just have it be that the cars themselves, they have to be, facial recognition when I get into the car and know I'm an adult driving the car, right? And that's where I think, again, hearing just from an average person's standpoint, like I hear the argument, but those types of things exist in other areas that we go about every single day, whether it's opening a bank account, going to, you're trying to buy a new home, you're starting a brand new job. Like when I started a brand new job, you have to give your birth certificate, your passport, your social security number and stuff, right? So like what happens if your company gets hacked? There's all these things that just in day-to-day life, we are putting ourselves at risk, but that risk is usually a risk we're making based on the value we're getting. And this goes back, to my overarching point is that I just don't see any tangible inherent value to explicit pornographic material, which I would argue is obscene. And I go back to the argument, that we've seen tried and true over the past how many years where, well, what separates expression, right? That's a free amendment, our First Amendment speech argument versus now, and we're putting a camera there to record it versus engaging in an illicit act of prostitution where you're probably paying the person regardless, but now where there's just no camera there. So that's where I think your average person hears it and they're like, no, I'm sorry. That's just, that doesn't correlate for me.
Sure. No, I mean, and I think that all hangs together. I think that hangs together on the surface, but there's a couple objections I would raise.
Yeah, hit me with that.
First off, the status of obscene content as protected, take it up with the Supreme Court. Take it up with Justice Thomas, who again.
I'll give him a call right now. Yeah.
Yeah, exactly. I'm sure you have Justice Thomas on speed dial.
He is. Yeah, he's number two, right behind my wife.
He's number two. I'd love to know who's number one in that case. Even Justice Thomas in this case acknowledged that there is a certain amount of protection that attaches to obscene content for adults specifically. So again, this is established First Amendment case law, and maybe your position is that we should take all obscene speech and sort of say this just has no First Amendment protection. We could ban it all today. We could criminalize all of it, do whatever we want to it, and that should be the new standard.
Which I don't think, by the way. Just so
sure. Fair enough. But that would require a different kind of change in the case law, and this is actually something that I said in the lead up to the decision being issued. That would be one thing, and I think there's some practical problems. There's all sorts of practical problems to making that kind of determination about obscene speech. There's all sorts of line drawing problems and other issues. However, what worries me specifically about this case, again, is the weakening of the First Amendment's barriers to age verification for speech generally. As I said, nobody wants kids accessing porn. That's not something that either side of the debate on this issue is advocating. The question, I guess, the way I would put it is that sort of within this framework in which the Supreme Court has recognized some protections for obscene material, how do we treat the issue of age verification? And again, if we sort of again decide that the burdens of age verification or the problems with age verification, the constitutional protections against being forced to verify your age and or identity before accessing online speech are upheld in every single case besides cases of obscenity, I would be far more comfortable with this decision. Now, to get into a little bit of Supreme Court Kremlinology here, as I said at the outset, I think that may very well be where we land after future cases. Once one of these larger age verification laws are brought up before the Supreme Court, I think there's a very likely majority that will narrow this decision specifically to obscenity. However, I also don't believe that is a. I don't necessarily think that decision, if I'm right, that the Supreme Court will go in that direction, will be unanimous. I think Justice Thomas, for one, discounts the burdens that age verification places on online speech. I think if I had to venture a guess, and please do not take this as gospel in any sense, or don't take me as an oracle on this kind of thing, but I would tend to think that you would have justices like Thomas, like Samuel Alito, like Neil Gorsuch, essentially say that age verification really isn't something that we should worry about, and that, again, as long as you can sort of say, we're doing all of this, say we're imposing all the sorts of burdens on speech, normal First Amendment protected, what we think of as quote unquote core First Amendment protected speech, as long as we're predicating restrictions on core First Amendment protected speech on protecting minors because we think there's some sort of interest in limiting their access to social media, that gets to a very dangerous place, again, because of all of the ancillary burdens which are then placed on adult speech. And I guess it's sort of missing. I think it's to focus only on the harms done to children when establishing a principle can miss some very important and very dangerous implications. And if I can just add one more thing on this, right? I think the principle that we set here for free speech generally is incredibly important. There is a sense that one gets reading the founders, who I think are very good on this, that the principles that we establish for government and for politics have important implications. If we set a principle for free speech, that free speech should be something that you can go out and do without having to verify your age or identity or compromising some part of your privacy or something that's important to you, which is, again, just the principle of the First Amendment that is very clearly stated in the First Amendment. If we take that principle and we start to compromise it and chip away at it in all sorts of ways, that leads to some very nasty places in which the United States does not protect free expression in the way that heretofore it has. And that, I think, is very bad. I mean, if you want to look at countries that do not have robust speech protections, look at the European countries, look at England. They're locking people up for all sorts of speech that we as Americans would never think is okay. They really truly do curtail what their citizens can and can't say. And one of the great things about America is that we have incredibly wide boundaries set around government's intrusions into speech. This is the country where Nazis can march in Skokie because there is a First Amendment right to that expression. This is a country in which the Westboro Baptist Church can say truly horrific and vile things because, again, we have a First Amendment that blocks the government from involving itself in the freedoms of conscience and the freedom of speech. So again, if we to retreat a little bit back to something I said before, if this decision is cabined specifically to obscenity, there are going to be certainly some problems with implementation. Some of them significant, some of them minor. That's a separate issue. But if this decision, as I think Justice Thomas intended it, even if a majority of his colleagues would not agree, is extended as a larger principle to be applied to all free speech, we are entering a very dangerous time.
And I guess my response to that would be, if we were able to draw a line of delineation here between the speech for adults and the speech for children, I think that's at the very minimum a decent way to break it down. I understand, right? Like the concern we have with regards to the limitations we're going to put on adults. But I just, at the end of the day, I mean, children are different than adults, right? Like children don't have the decision-making abilities that adults have. Children don't have the context of the things that they're consuming. And, you know, it is one thing, we have to have parents play an important role here, right? Like parents, you have to be aware of what your kids are consuming. If your kids have a smartphone for whatever reason, be involved with your kids. Know what, like put parental locks and guidelines on those smartphones. Like if you have like teenagers, for example, who are growing up, you want to make sure that you're addressing this information, because, you know, going back to the harm that we were talking about, right? I think, you know, there is very real harm that we are seeing with these both social media websites, as you mentioned earlier, but also with these more obscene types of materials impacting children. We're talking about long-term porn addictions. We're talking about the inability for them to have, you know, legitimate relationships with people, which is having more, externalities. That's the word I was looking for. You know, and it might not be that you consume obscene or pornographic material and then you see an immediate negative consequence. That might be a delayed consequence, right? And it's more difficult for us to realize the impact versus if it was, you know, a 12-year-old driving a car and then hitting somebody and accidentally killing somebody because they weren't supposed to drive a car. Go ahead. I see you want to say something. Go ahead.
Yeah. So I have three things. I 3 points to address that. So first off, the part of the problem with age verification specifically, or really any policy that requires technology to determine or to request the age and to verify the age of users, is that there is no way to separate underage users from adult users, because you can't know what the age of the user is until you've done the verification. So
really quick, let's noodle on that, because if that's the case, and I know, you know, with the advent of a lot of these blockchain technologies, I can almost guarantee there's going to be a solution that is built that can help, you know, segment the PII, the personal identifiable information, from the actual individual relative to accessing the website. Like there are sites you can use right now for transcription tools, for example, where they will listen to an entire conversation, they will spit out the transcript, and then as soon as that transcript is spit out, the actual like call, the audio is gone, right? So like those technologies do exist. I'm not saying they're perfect, but I mean, just to say, like, because that's how it is right now, and that's why we can't do it, I just don't feel that's a very strong argument to say we can't do it with the future as technology advances and gets more and more intuitive.
Well, that may be true. That may be true, but at the same time, the law has to deal with the technological status quo. And there are people who are working on verification services that are supposed to be much more secure. There have been great strides made on those technologies. However, first off, that's not how the law would work. That's not, for example, how the Texas law would work at this time. Also, very often the sorts of people who put forward those technologies will assure all of us that they have done what they need to make or to alleviate the privacy concerns, and then somebody gets hacked, and then I don't know, compliance data needs to be maintained to prove that companies are within the law, and then the data is not completely erased. There's all sorts of technical problems in the status quo that mean that the privacy and security concerns still obtain. So that's thing one. Thing two about on the second point about social media, is that the data, the data that purports to prove that social media has tremendous negative effects on minors' mental health is very shoddy at best. All sorts of holes have been plugged through it, methodological and others. And where the research seems to be much more secure and much more I should say robust, is that there are certain types of children for whom social media, especially lots of social media access, is very detrimental. But the people who say that it's, you know, digital fentanyl, or, you know, choose your metaphor, they have ran past the hard conclusions that we have found in the research, and there is a lot of overstatement, both of the conclusions of the research that we have and also the surety with which those conclusions have been reached. And I'll let you respond to that. But then the third thing I would like to get to is what parents can do, because I think this is probably something I should have brought up earlier, but there's actually a lot that parents can do, and there's even certain things that the government can do, short of the kinds of invasive
solutions. We like it. Let's hear it.
Yeah. Well, as I said, I probably should have talked about this a little bit as well, because I guess the argument, if I could steel me on the other side, the argument would be, if there's no solution other than age verification, then, you know, come what may to these larger concerns that I have about free speech and the rights of adults, you know, we might just have to bare our teeth and put in some of these restrictions. I could quibble with that. We could have conversations about that, but I don't think it's a concern worth dismissing out of hand. But the fact is, part of the problem, both with age verification laws and with other social media regulations that are purportedly designed to protect children, is that it is an effort to absolve parents of responsibility to parent their children online. There are a host of child safety technologies at nearly every level of the digital stack, even from like the Wi-Fi network level to the device level with phones, to the app store level, to the app level with social media on browsers, that allow parents to monitor and to a large degree control what their children see and whom they're interacting with, and a lot of other aspects of children's online lives. And I think there's a twofold problem that has led to the availability of these tools not translating into effective management of kids and the effective protection of kids on the internet. And the first, I think, is something along the lines of ignorance and the barriers of using new technologies, which can be hard to figure out sometimes. And we've seen states such as Florida and Tennessee implement digital education tools. And I'll talk about Florida for a second, because theirs has been the Florida education program has been in effect for a little while now. And I was talking to a parent in Florida, and he said it's actually really great, because what they do is they break down some of these tools, they demystify how they work, and they really help parents exert parental control, not the control of the state, but they tell parents what tools they have to protect and parent their children online. And again, these tools are incredibly effective when implemented properly. And so the more that parents can get a handle on how to use these technologies and just have an awareness that they exist, the more effective parents will be at actually doing the sorts of things that some of these problematic laws are attempting to do. And again, I think parenting is the job of parents, not the government, full stop. And the second problem is that some parents don't care. And I don't mean that in the sense that they don't care whether their children access some sort of problematic content, or they don't care about whether or not their children are doing well. But there's certain parents who don't want to go through the work of monitoring their monitoring their kids' online lives, monitoring their kids' device and social media use, and having some of the tough conversations and saying no sometimes in a way that in practice translates to effective controls on their kids doing these things. And I think the good news and the hopeful note is that more and more parents are becoming aware of some of the problems of letting, say, a 10-year-old, to use an extreme case, letting a 10-year-old go on any internet platform or website or app and interact with all sorts of adults and other strangers and sort of live their lives as an adult online. And so more parents are actually getting involved in their kids' lives. And I think that's actually the solution. Not least I will add, because it's one thing to try to impose a blunt, sort of some kind of blunt protection, which always lends itself to kids finding ways around it. And it's quite another to have a parent who is on the ground, actively involved in the process of raising their children and being able to tailor their approach to child protection to their child, to their family, being able to monitor exactly what their kid's doing. The fact is that the government can't monitor the internet behavior of every child. There's too many children. The government doesn't work that way. The government can't love you. That's another issue. But parents do love their children. If they are only monitoring, if we rely on parents to monitor the goings on within their family unit, it will be far more effective than trying to impose one top-down standard and then allowing parents to check out.
David, it has been truly a fun conversation. I kept you way longer than I promised I would, because I think we got into a really fun back and forth here. And frankly, like, this is the conversation that your average person's going to have, right? And that's why I wanted to make sure we really dug into things today, because, there's a lot of folks who are coming at from, the family video approach that I brought up earlier, or the DMV approach. But then there's a lot of folks who are more, call them free speech absolutists, or, folks who are very concerned about security and privacy and what the government is able to do or not do in terms of telling us what we can or cannot consume. And trust me, I don't want nanny government in my life, right? Nobody wants nanny government. But going back to the position you rightfully asserted, nobody wants kids to have access to pornography, or in this case, explicitly like obscene pornography where sexual acts are being committed. And I think, where a lot of folks, David, at the end of the day, are looking for government to have a solution isn't necessarily the solution of stopping kids from always accessing this stuff, but at the very least giving us a baseline threshold of like, this is what is good and this is where it's not, right? And not necessarily to say that government's going to be the arbitrator of that always and like actually enforcing it, but at least giving kind of a standard. And when you have people look at, the difference between obscene pornography and just, normal pornography, or prostitution rather, like the difference is there a camera there, right? And that for your average person feels silly. Like, that's not a freedom of expression. That's just a way to work around a rule that's been put in place, right? But to your point, that's what we do. We look for workarounds, and kids are phenomenal at finding workarounds, right? So that is, to your point, where I think the ultimate solution really comes down to is absolutely parents getting involved in their kids' lives today. You have a kid who's, they're in their single digits under the age of 10, start talking about the importance of being aware of what you're doing online, and that you're not, you're not going online in a bubble that you can access anybody. And by the way, parents, be aware that if you give your kid one of these little supercomputers, right, and they have access to everything in the world, that means that the whole world has access to your kid. So you have to be, as a parent, a smart consumer, but also a smart parent in terms of what you're allowing your children to access. And we go back to the whole Elsa Gate with YouTube, where parents would let these kids just sit down in front of YouTube, and then 6 videos later of autoplay, they're watching some just bonkers, out of this world, grotesque video that's literally messing with kids, like their brains as they're developing. There's very real harm when parents just kind of do the autopilot parenting. So parents get involved, right? And no, the answer isn't always to go in and say, "Mommy, Daddy, government, please help fix this. Help us, help us ban things that we don't like." But I will say, I do think that there is, at the very least, an argument to be heard about the difference between children versus adults. And I understand we don't want to always add more stress to adults accessing things. However, the world changes, right? We are now able to access the entire world via a smartphone. That wasn't the case in 1776. Now, I already can hear folks, the slippery slope argument. Well, Brian, what about automatic machine guns? Those weren't necessarily something that was, tried and true in 1776. I know, I get that. But I also think there is a demand right now from our population for just some common sense, right? Where we can look at things in a more common sense perspective and hopefully come up with common sense solutions. My approach would be, let's do those outside of the government, because we don't want government just, yes, knowing based on popular opinion what the rules of the day are going to be, because that popular opinion can very obviously change. We've watched that happen here in the past 10 years. A lot of folks who were more, rock rib Democrats are now starting to say, well, maybe I'm a Republican. And a lot of Republicans are like, I'm never Trump. So you see people flip back and forth. So it is important not just to go based on what's, where the pendulum has swung that day, but going back to, I think the overarching theme here is that, parents, you got to get involved. No, we're not saying that this stuff is good, by, just morally good by default, but rather there is, there is a lot of questions around a lot of this stuff. So if you're as a parent, you're like, well, damn it, they didn't decide right, or yes, they're deciding right regardless. Get involved. That's going to be the best way to both make sure your kids are consuming what you want them to consume, not consuming the things you don't want them to consume, and hopefully across the board, not infringing on other adults' lives. David, that's my final thoughts for today. Bring us home. What are your final thoughts? And of course, where can folks go ahead, reach out to you if they want to tell you all the things you got wrong today?
Well, I'd certainly invite people to
don't worry, they do it to me all the time too. So it's not you, it's me too.
Yeah, please feel free to find me and harass me online on Twitter, now known as X, at David B. McGarry. I guess the way I would wrap things up is that technological advancements are very destabilizing to society. We see this again and again and again, from the advent of the printing press to the Industrial Revolution to the digital revolution today. We face new problems when we are using new technologies, and it is sort of a fact of history that new technologies usually bring with them calls for new impositions from the government and new regulations. And that can be very dangerous to free societies and to free people. It is very easy to look at a problem and take a very blunt force approach to solving it, take a very heavy-handed approach to solving it. And it's a lot harder to sort of take the time to figure out more complex solutions that involve more than just government mandates. But in the end, not only is a free society important to preserve and important to protect, but also very often finding other more complex solutions that oftentimes involve families and civil society more than government are actually far more effective. So if you are worried about your children on either accessing obscene material or just worried about their relationship with the internet generally, I would encourage all of your listeners and your viewers to look through some of the tools that they can use, that they can put onto their kids' devices, and then have it's work, but do the work and have the conversations with their kids and really get involved with parenting their kids in the digital world just as they would in the physical one.
Parenting, it requires a lot of work. So yes, parents, you're going to have to put in a lot of work. And by the way, in terms of putting in some work, if you want to go ahead and put in some work to learn more about what David's doing, head over to the article I'm sharing here on screen, his article at Counterpunch, What's at Stake as Age Verification comes before the Supreme Court. We'll make sure we include that link in the show notes if you want to brush up on your reading. But other than that, no, David, I think, across the board, I'm right there with you, right? Like, parents, take some ownership, get involved in your kids' lives, because if you're not going to get involved, somebody else is. And it might not be the most, the most upstanding members of society that you would hope. So, David, I really appreciate you coming on the show today. Obviously, we're rolling through some of these objections here, so I appreciate you, rolling with those punches. But with that being said, folks, if you got some value from today's episode, go ahead and give it a share. When you do, tag yours truly at B Nichols Liberty on X, Facebook, or Instagram. You can find the show wherever it is you consume your podcast content or your video content. But with that being said, Brian Nichols signing off here on the Brian Nichols Show for David McGarry. We'll see you next time.
Thanks for listening to The Brian Nichols Show. Find more episodes at briannicholsshow.com.